Mr. Biggs appears for the Secretary of State.
I should have asked for the case to be called on.
Appealing the matter of the King on the application of Ashokkumar Dhandapan and the Secretary of State for the Home Department.
Yes.
Lords, I'm afraid there are a couple of housekeeping matters. There is an email that my instructing solicitors sent to the court yesterday. I'm not sure if that email has reached you.
I don't think so.
So I have a hard copy of that email to hand up.
Yes, please.
We both agree that you should admit this email on a debene assay basis. You'll hear submissions on admissibility, and you'll decide at the end what to do about it.
Right, let's see it then.
And then, my lord, there are a couple of additional authorities. They are cited in Miller and Friends' supplementary skeleton argument.
Right.
Very good.
Yes. Maybe an issue about whether the witness statement is admissible, but at least we ought to have it complete rather than incomplete. Right, and the authorities we can come to later. So this goes in supplementary bundle. After page,
Probably after page 14.
yes. Yes.
My apologies for that. My lord, Miller and Friend seeks to show you section 6 of the Administrative Court Judicial Review Guide. That was sent to the court electronically. I'm not sure if you have it, but I do not propose to pen hard copies up at this stage. What it says is uncontroversial.
We've got Administrative Court Judicial Review Guide, section 6.5.
Yes, tab 4. You have section 6 in the hard copies. It is section 6.5 you have behind tab 4. It's paragraph 6.4, section 6.4 that Miller and Friend seeks to show you.
Oh, I see. Right. Well,
You don't have it. I mean, I do not propose to hand those up now unless you want us to. What it says is uncontroversial.
right.
Very good. So, Lord, in my this factual submission, there are four issues before the court. First, whether the appellant's notice filed with this court was 1 day out of time, and if so, whether time should be extended.
Yes.
Second, whether the court can take into account fresh evidence adduced by the appellant following the decision of the Upper Tribunal. Third, is it arguable that the Secretary of State's decision dated 23rd of March 2023 cancelling the appellant's leave to remain was not properly served on him. And fourth, can he be refused permission to apply for judicial review on the grounds of delay?
Right. Just speaking for myself, point one,
Yes.
we really don't want to take that as a preliminary point. We're inclined to think that if you succeed on the merits, we would not shut you out on the basis of this rather common mistake of date of decision as against seal date and so on. There's rather a lot of jurisprudence on that. We don't want this case to add to it, subject to anything Mr. Biggs says when the time comes. Point two, you may be in difficulty on that, but does it matter? There's a witness statement of 1st of September 2023. There's then the further witness statement of April 2024. But if you're right on the point of principle, your question 3, then you don't need a second witness statement, I think. And if you're wrong on the point of principle, then the witness statement doesn't help you. That's where I am at the moment. Your point 3 is perhaps the most interesting one. I don't know whether either of my colleagues would like it.
So do I. Right. I'm very, very grateful. Lord, of course, I'll keep these observations fairly in mind, but we'll address you very, very briefly on the first two issues in turn, just to explain where things are, and we'll then address you as to issues 3 and 4, the issues that are sort of directly relevant to the merits of the case.
It might be good for our general education, but wouldn't it be helpful if see whether Mr. Biggs makes anything of those points?
Yes, I thought from a reading of Learned Friend's Skelton argument that he invites the court to find that the appeal is out of time and not to extend time and not to look at the fresh evidence. But of course, if you want to ask that question, I have no issue with that.
As I said, there is at least one point in this case which, as I understand it, the Home Office would like decided, and to say, well, this appeal was filed one day late, and so we're going to refuse an extension of time, and we need not hear any other argument. We'll put off this question for the next case, which to come to the Court of Appeal seem rather silly.
Yes.
I'm not asking us to do that, are you, Mr. Biggs?
My Lords, you have our position in the supplementary skeleton argument, but in the light of my Lord's observations, I don't propose to say anything more about the question of whether to grant relief from sanctions.
Thank you.
I'm very grateful. So I need not to address you then on issue 1. Just simply to say that, well, of course, I accept that the appeal is one day out of time, and I need extension of time. But my learned friend is not seeking to oppose extension of time, so I invite you to extend time and consider the appeal on merits. On fresh evidence, my Lord, I completely agree with what my Lord Lordis has been said with respect. If I'm right on merits, I don't need fresh evidence. Just to be clear, and this is the same submission that I made last week when for the Secretary of State,
Yes.
before Lord Justice Bean and my Lord Justice Peter Jackson, when they're sitting with the Vice President. I accept entirely that fresh evidence is not relevant to the question of whether there is an error in the Upper Tribunal's decision. But if I persuade you that there is an error in the Upper Tribunal's decision, surely you can look at fresh evidence at that point to decide the appropriate order to make.
What are you going to ask us to do if you persuade us?
If, my lord, I'm able to persuade you that there is an error in the Upper Tribunal's decision, I'll invite you respectfully to set aside that decision, grant permission to apply for judicial review, and remit the claim to the Upper Tribunal for a trial.
Yes.
So unless there are any questions, I'll address you then on issues 3 and 4.
Yes.
Very grateful. So what I propose to do, again, subject to any observations, is to address you first on the law, and we'll then make submissions on the facts, and we'll take you to the key documents. So on the law, may I respectfully start by taking you to the primary legislation behind tab 1 of the authorities bundle. You have the relevant provisions from the Immigration Act 1971. And it is section 3 of that act that empowers the Secretary of State to grant leave to enter or remain to a person. And if you look at subsection 3, you'll see, which is page 3 of the bundle, you'll see that that provision empowers the Secretary of State to vary a person's leave to remain. So if a person has leave to remain for 2 years, the Secretary of State can vary it to 2 months. Now, how the Secretary of
Which subsection?
subsection 3, my lord, in case of a limited leave to enter or remain in the United Kingdom, a person's leave may be varied. So variation includes extension of leave or reduction of leave, cancellation of leave, curtailment of leave. Now, how that bar is to be exercised is governed by section 4 of this act. Now, you have that section at page 17 of the bundle. And my lords will see that subsection 1 says that the power to give leave to remain or vary leave to remain shall be exercised by the Secretary of State. And those powers shall be exercised by notice in writing given to the person affected. Given is the word that I respectfully place particular emphasis on. So the only way in which the Secretary of State may exercise the power to vary leave is to give notice in writing to the person affected. If notice in writing is not given, there is no valid grant of leave to remain, there is no valid variation of leave to remain. This is the proposition that this court endorsed in a case called Amadi, which you have behind tab 6 of the authorities bundle. May I respectfully take you to page 176 of the bundle and ask you respectfully to look at paragraph 18. At paragraph 18, Lord Justice Sullivan quotes the decision of the Upper Tribunal made in that case.
I'm sorry, would you give me the paragraph number?
Yes, paragraph 18, my lord.
Thank you.
And if I may ask you to look at the quotation at paragraph 18, the second last sentence of that quotation. This is what the submission was made to the Upper Tribunal, which the Upper Tribunal accepted, that unless notice of decision has been given in writing, the application has not been decided. The Secretary of State argued that that was wrong. and there is no requirement in law to give a notice in writing. That argument was rejected by this court, and the ratio of this judgment is at paragraph 22. Last two sentences of paragraph 22. The notice in writing is not a subsequent step following the exercise of the power. So it's not that the Secretary of State grants or vary leaves and then takes a subsequent step of issuing a notice. Giving of notice is the way the power is to be exercised under the statute. So if a notice is not given, the power is not validly exercised.
What type of decision or notice was in issue in this case?
A refusal of leave to remain. But it makes no difference because whether it's refusal of leave to remain or variation of leave to remain, both are governed by Section 4 of the 1971 Act. So this is Amadi Malot. May I then respectfully take you to tab 12 of the authorities bundle, where you have the judgment of this court in Mahmood, where Amadi was considered, and the ratio of Amadi was identified. And the paragraphs that are relevant are paragraphs 41 and 42.
Sorry, which tab?
Tab 12, my lord. My apologies.
287?
287, yes. So tab 12 is the judgment of this court in Mahmood, Lord Justice Beatson. Paragraph 41 is the submission, and 42 is the answer to that submission. That Section 4 of the 1971 Act explicitly provides that the power to give leave to remain or vary any leave, my lord, this is the point, shall be exercised by notice in writing. Accordingly, the fact that internally the Secretary of State may have decided to refuse leave is legally irrelevant. What is relevant is the date and time of the service of the notice in writing to the person affected. Until then, there is legally no decision. So service is absolutely essential. Giving of notice is what the statute requires.
I don't think Mr. Biggs is going to suggest otherwise, is he?
Lord, of course, I'll take you,
Yeah.
of course, next to the primary legislation, the secondary legislation and the key authorities. But I would be inviting you, of course, to look at the secondary legislation in the light of what Section 4 says. The word that Section 4 has used is given to the person affected. Lord, so this is the primary legislation and two authorities on it. If you then, Lord, go to tab 3 of the authorities bundle, you have secondary legislation. Sorry, not tab 3, my fault, it's tab 2, page 19. This is the Immigration Leave to Enter and Remain Order 2000. And this is made pursuant to the 1971 Act. May I ask you respectfully to go to page 28 of the bundle, where you will see Article 8ZA. A notice in writing, D, varying a person's leave to enter or remain, may be given to the person affected as required by Section 4.1 as follows. You'll see that the word given is used, that is picked from the primary legislation. But if you then look at Article 8ZA2, you'll see that you'll see that word given is used in 2A, but the word sent is used in B to F. given and sent. Of course, if you give a notice by hand, no doubt that is giving of the notice under section 4.1. But word sent is used, and for the relevant purposes, it's to be sent electronically to an email address. Now, sending of an email address, sending of an email or a letter or a fax does not automatically mean giving of notice to the person affected. There's a difference between sent and given. Now, that is the difference that secondary legislation expressly recognizes, because if you look at the next article, Article 8 ZB, that concerns with sending of the decision. Where a notice is sent, where a notice is sent in accordance with Article 8 ZA, it shall be deemed to have been given. So the legislation recognizes that sending is not giving, but it creates a presumption that sending of a notice means giving.
Sorry, just slow down a bit, just a minute. Can I just look at 8ZA and B again?
These provisions were brought in to alter the effect of a prior decision of the UT, were they?
Yes, Said. Yes, yes. Yes, so where, for example, the Secretary of State does not have a person's email address or residential address, prior to Said, it was impossible for the Secretary of State to cancel or curtail that person's leave to remain, because unless the Secretary of State finds that person, the Secretary of State is not able to give the notice to that person. That's what the Upper Tribunal said in a case called Said. Article ZA, 8ZA and ZB were then inserted in the 2000 order to deal with that problem. That if a notice is sent, that creates a presumption that it has been given. But it's nothing more than a presumption, a rebuttable presumption. So the three submissions that I make about this provision. First, sending is not giving. Second, sending an email creates a rebuttable presumption. The appellant, the applicant can rebut it by demonstrating that the decision has not reached him, it hasn't been given. And the third point is that this also applies to emails. That is quite clear because Article 8ZB expressly refers to sending of notice by fax or email, document exchange or courier, 8ZB 1B. So sending of an email is not conclusive proof of service. It creates a presumption that is rebuttable.
There's just one proposition that your second one, where you said that it was a rebuttable presumption and that the individual could rebut it by establishing that it had not reached him.
Yes.
It would be more correct, wouldn't it, to say to establish that it had not reached his email inbox.
No, my lord. That wouldn't be the correct analysis. It makes no difference on the facts of my case, but one can, and I'll take you to the relevant case law. But one can contemplate a scenario where an email is sent to a person, and that email is received in the inbox of that person. Now that is a shared inbox. someone else looks at it before the appellant and deletes that email.
Well, that's Escobar.
Yes,
Yeah.
or the email reaches his inbox, but is then intercepted by the
So,
other.
so can we leave it at this point in this state? Namely that it's one of the matters in issue or matters that we might have to consider
Yes.
in the context of this appeal, whether directly or indirectly, as to whether your formulation, which has not reached him,
Yes.
is the correct formulation or whether it's some other formulation.
Yes. No issue with that. Yes.
Just going back to your points, you said your first point was sending is not giving.
Yes.
I just query that. Your second point is 8ZB1 is a rebuttable presumption, not a conclusive one. 8ZA seems to say sending is giving. That or a notice may be given as follows. One of the methods of giving is it may be sent electronically to an email address provided for correspondence by the person concerned.
Yeah.
So a notice sent electronically to an email address provided
Yes.
for correspondence by the person has been given, or at any rate is deemed to have been given, unless the contrary is proved.
So, my lord, if the 2000 order had ended at Article 8ZA and there was no 8ZB, then I would have been making an argument that the 2000 order is ultra vires Section 4 of the 1971 Act, because the primary legislation says that power to grant leave shall be exercised by notice given to the person in writing, and the secondary legislation changes that to sending.
You're saying that giving includes or implies receiving, whereas sending doesn't.
Yes.
If my lord gives me a birthday present tomorrow, or whenever it is, my birthday, and he gives it to me in person, he's given it to me. But if he sends it to me, he hasn't given it to me unless I receive it.
That's it, yes. And the secondary legislation actually expressly recognizes it by Article 8ZB. And that is the reason this isn't ultra vires, because 8ZB makes it absolutely clear that there is a distinction between sending and given. That article expressly creates that distinction. A notice is sent, it shall be deemed to have been given unless the contrary is proved. So sending, Lord is absolutely right, is not given. But if Lord Justice Bean sends a present to my Lord Justice Baker by courier, the rebuttable presumption is that my Lord Justice Baker would receive it unless someone intercepts and it goes to Lord Justice Peter Jackson.
Sorry, of course you're right. As a general proposition, if this order didn't exist at all, of course sending is not giving.
Yes.
Question, but 8ZA sets up a system, and 8ZB makes it clear that there is a presumption that what is sent is given, but it can be rebutted.
Yes, absolutely. And this is my third proposition, that is equally true when a notice is sent by email, because email is something that is expressly referred to in 8ZB.
Yes.
So the legislation recognizes that even sending of notice by email is not conclusive proof of notice being given. It creates a rebuttable presumption. So this, in my submission, is the correct analysis of the law. Now, two authorities of this court that, in my respectful submission, support this analysis. First is the judgment in Alum. You have that judgment behind tab 7 of the authorities bundle. Well, this concerns the effect of section 4 of the 1971 Act and articles 8ZA and 8ZB. And may I ask you respectfully to look at first paragraph 19, which you have at page 188. Look at the middle of that paragraph, line 4, article 8ZB only creates a rebuttable presumption which arises if one of the methods of sending in article 8ZA is followed. So it could be post, courier, email, fax, but it creates nothing more than a rebuttable presumption.
This actual case was recorded delivery mail, wasn't it?
Yes.
Hello.
Yes. Now, if you then go to page 191, and if you look at paragraph 29, the legislation does not require, I entirely accept, that the applicant should have read and observed and absorbed the contents of the notices in writing, merely that it be received. So, for example, if a letter is sent by post, and if the applicant decides not to open it, that there would still be effective service. But you'll see the words "that it be received" are the words that Lord Justice Floyd used. So the requirement is that the notice is received by the applicant. And then paragraph 30, the point that my Lord Justice Bean made, that if a notice is given to a person by hand, then that, of course, is giving of the notice. That is expressly recognized. A receipt of an email, and this is nothing more than an example, as it is clear from the words, for example, will be affected by the arrival of the email in the inbox of the person affected. The same applies to sending of documents by post, unless there is some positive evidence that the mail which so arrives is intercepted. If a document is sent by post, it is intercepted
Before it arrives at the address.
Before it arrives at the address, yes. Then that is not effective service. Likewise, if an email is sent, but it is intercepted by an IT glitch or by system security, etc., if it does not arrive the inbox, here's submissions on the other point, then that means that it has not been received by the applicant. Sending of an email creates a rebuttable presumption. The applicant must prove that the email has not arrived in the inbox.
In these cases, is it right to understand that the choice of how notification is to be given is with the individual? In other words, your client would have been in a position to say, I would like to be communicated with by post to number 1 High Street, or by email, or maybe by some other means as well. In other words, it's the individual's choice of target.
Yes, I'm afraid the correct answer is that, well, it is actually the Secretary of State's choice. So the Secretary of State will usually have the applicant's address, will have email, will have the details of his solicitors, for example. The 2000 order allows the Secretary of State to effect service on in the way that she wants.
Right. Let's suppose somebody doesn't have an email address.
Yeah.
And so they only fill in a physical address. That's acceptable, but the consequence will be that matters will be sent by post to the physical address.
Yes, yes, but at a yes, Lord is absolutely right again. But given that, Lord, you've asked that question. I mean, you now need to have an email address to make an application. But Lord is absolutely right that if there is no email address on the record, the only address is the residential address, then the Secretary of State can only effect service by sending the notice to that address.
Can I ask, is it now convenient just to ask the point arising out of Escobar?
Yes, yes.
Because two scenarios. First of all, I think in some cases, someone can have a legitimate access to another person's email address.
Yes.
For example, I think at one point, I'm not sure if it's still the case, judges' clerks had access to the judge's email account.
Yes.
If, hypothetically, the judge's clerk were to delete the email after it arrived, that would not prevent the email having been received, would it, on your analogy?
In my respectful submission, it would. And there is the next authority that I'll take you to will assist you on that, the judgment of this court.
We won't take my point any further. You take us to that.
But I'll completely understand the point. And once I've shown you paragraph 32, I'll take you straight to that authority.
Okay. All right.
So paragraph 32 is the test to be applied. And the submission that I'll make in due course is that this is not the test that the Upper Tribunal applied in granting permission to apply for judicial review.
In refusing.
Sorry, in refusing permission to apply for judicial review. So paragraph 32, the test that should be applied is whether the material before the court raises a factual case which, taken at its highest, could properly succeed in a contested factual hearing. It's the same as the age assessment scenario. The Upper Tribunal must decide whether the evidence that is adduced by the applicant is capable of belief. If it is, then permission should be granted. If it is hopeless or the answer is inevitable, then permission be refused. There's quite a modest threshold to meet.
33 is also helpful.
Yes, where you have somebody. Yes, where you have summary of the conclusions. Yes. The question is whether the applicant has a real prospect of establishing that the document was not received. That means that he has a factual case that is capable of belief. The factual case must be taken at its highest. And if that threshold is met, then subject to discretionary factors, the court will grant permission.
In some types of immigration appeal, the appeal is to the first tier tribunal. Appellants commonly give oral evidence.
Yes.
In this type,
Yes.
the challenge is by way of judicial review, where appellants rarely give oral evidence, although your client offered to.
Yes.
What happens in real life?
This is this is the kind of judicial review where there will be oral evidence.
Can be, right.
Where
Not very long.
not very long. Yes. But of course, and I'll address you on the facts. But the judge will hear oral evidence, will decide whether to accept or reject the appellant's evidence, a fact-finding function that the judge would perform.
Yes. Anything else from Alan?
No, that's Alan. Now, the next authority is Kuly, that in my respective submission touches on the question that Lord Justice Baker raised. It's tab 11. Now, Kuly is a case where a decision is sent by the Secretary of State to the applicant's address, the address of those representing the applicant. The decision is referred as decision 3 in this judgment. If you look at paragraph 7 at the end of that paragraph, you'll see what the decision is. And that decision is sent by recorded delivery. It is received at the address, and someone signs the receipt. The applicant says that, well, the notice has not reached me, and there is therefore no effective service, although it is sent by recorded delivery to the address of those who are representing me. There is receipt, but they never received it because it was intercepted within the building. Someone else picked it. And one of the issues before the court was whether there was effective service. If you go to page 269, if you look at paragraph 3, you will see 3 submissions that are made. Sorry, my apologies. Before you do that, if you look at paragraphs 50 to 52, Lady Justice Elizabeth Lang refers to the legislation that I've just shown you, and then summarizes what Alam has decided in 2 paragraphs, paragraphs 51 and 52. And this, in my respective submission, is an entirely accurate summary of that judgment. And the submissions that I've made thus far are entirely consistent with that summary. If you then look at paragraph 58, you'll see 3 submissions that the Secretary of State made. And it is the second submission that is relevant for the present purposes, that decision 3 had been properly served. It was sent by the Secretary of State. It was received at the address. Someone signed the receipt, and therefore there is effective service. If you then look at page 270 and paragraph 61, you'll see that a submission is made that the appellant cannot possibly discharge the burden of showing that the decision had been effectively served. The Secretary of State has no burden to discharge. The burden is on the applicant to rebut the presumption. There is then discussion of other issues, and if I may take you to paragraph 74 and 75. So this is where Lady Justice Elizabeth Lang considers the immigration rules. Immigration rules reflect the 2000 order for the present purposes. It's quite clear from paragraph 74. The legislation says that a decision is sent, is deemed to have been given unless contrary is proved, the same as the 2000 order says. In other words, proper postal service is taken not only to show that the decision has arrived, but further that the decision was given. The assumption can be displaced by the evidence to the contrary, but this must include evidence showing that, in fact, the decision was not given to the applicant. This, I think, was the point that Lord Justice Baker was troubled with. If you then look at paragraph 75, Lady Justice Elizabeth Lang says that, well, that point is arguable. It is arguable that the decision was not properly served, the applicant had produced materials indicating that although the correspondence was received at the address, but someone else picked it and then did not give it to the applicant or the applicant's representative. So if Lord, a clerk receives, to give the example of Lord, a clerk receives an email and a correspondence is sent to one clerk, another clerk picks it and does not give it to the clerk in question, there is no effective service. So this, in my respect, submission is the authority for the proposition that it is arguable that even if there is conclusive evidence that the notice was received at the address, that too still creates nothing more than a rebuttable presumption that it has been given, which the applicant can seek to displace by producing evidence.
Without diving into this, this was a case where, although it arrived at the address, it didn't arrive at the address of the agent of the applicant, because somebody who was not authorised intercepted it before its arrival at the place where effective service would have been achieved.
Well, yeah.
It wasn't, as it were, that it arrived in the whatever it was, solicitor's office, and then somebody went into the solicitor's office and removed it. It never got into the hands of the people who were the agent for the applicant. Is that the analysis?
Yes. So I mean, of course, it's the same building, same address. The package is delivered, but Lord is absolutely right that it did not reach the solicitors. Someone else picked it.
So the receipt was, as it were, signed for at the doorstep.
Yes.
And it didn't then make it to the person for whom it was intended.
Yes. So the submission that this authority supports is that arrival at the address is not conclusive proof of service. The applicant can seek to displace the presumption, and whether to accept the applicant's case or reject it is a question for the fact finder.
So really your point is unless it's actually given to the person in their hand, in every other case, there's a rebuttable presumption.
Absolutely, yes, that is my case. Article 8 ZB expressly says that. It talks about sending of notice. If you look at Article 8 ZA first, you'll see that the first method is giving of notice by hand. And then all other articles say sending. So if a notice is given in person's hand, that is conclusive proof of service under Section 4. But if it is sent, then it creates a rebuttable presumption. In some cases, and in whether that presumption is rebutted is the task of the fact finder. It may be easier to rebut presumption in certain cases. It may be difficult to rebut the presumption in certain cases. But that is the task of the fact finder. That appeal, of course, failed, not because of that point, but because of other reasons. Lady Justice Elizabeth Lang said that that point was arguable, but other points were not, and therefore the outcome was inevitable, and the appeal therefore failed. And that is paragraph 78, where you have the conclusion.
Yeah.
These are the two authorities of this court that are relevant. The final authority is ECWA, which you have behind tab 8 of the bundle. Milan Friend invites you to disapprove what the High Court has said. But in my respectful submission, that is not an invitation that the court should accept. The judge's analysis of the law, in my respectful submission, was plainly correct. The judge, Mr. Justice Sheldon, discusses the relevant law, section 4, the 2000 order looks at relevant case law. And then if you go to page 206,
Sorry, can we just situate very firmly what is said to have been the nature of the rebuttal?
yes,
It arrived in my inbox, but my estranged wife deliberately deleted it before I saw it.
yes,
So that's which is in distinction to Kelsey,
yes,
Yeah.
yes.
for the reasons we just discussed.
Yes, but yes, you'll see from the paragraphs that I'm taking you to, but that the point that the applicant was seeking to make was quite speculative. He wasn't saying that I know that my wife had deleted it. He said that, well, there is a possibility
I'm
that.
just reading from the head note, that's why I thought it was what he said.
I'll take it. Yes.
Anyhow, sorry, I interrupted you when you were getting
So,
the paragraph.
so page 206, paragraph 28. The order does not state that once an email enters the applicant's inbox, it should be treated as it has been given to the applicant with no possibility of rebuttal. Well, if Parliament had intended for that course of action, it surely would have said so. Would have said so in Article 8ZB. But there is no exceptions for emails. In fact, Article 8ZB refers expressly to emails. And then the point that I made, where a notice is given by hand, then there is no deeming provision or possibility of rebuttal. Article 8 ZA2A says that. Parliament could have said that the same applies to emails entering inbox, but did not do so. Paragraph 29, the judge refers to the judgment of Lord Justice Floyd in Allen, says correctly that what is said about emails was merely an example. And then paragraph 30 contemplates the possibility of email being intercepted once it has arrived in an inbox.
What do you want to say anything about how he deals with what Lord Justice Floyd said in Alam?
Lord, that with respect is entirely correct. What he says that when I showed you the relevant part of the judgment of Lord Justice Floyd in Allen, I highlighted the words, for example, when Lord Justice Floyd referred to the email scenario. So there's no doubt that that was an example. And there's also no doubt that that was obiter, because that case wasn't about emails. And therefore, the judge is absolutely right that Lord Justice Floyd wasn't sort of rewriting the legislation and saying that sending of a notice by email is conclusive proof of service as soon as the notice enters the inbox. This is not what Lord Justice Floyd was saying.
He was saying that it should be treated as given.
Not the email, technically. I mean, of course, the letter, unless it is sort of intercepted.
Could you just help me with this? On your analysis, if one was leaving aside email, one was considering delivery to a domestic address, it is delivered to the home and placed on the hall table by somebody. And then somebody else picks it up and puts it in a pile which ends up in the bin by accident.
Yeah.
And amidst all of this, the person who's the addressee doesn't actually ever see it.
Yes.
How does that play out?
Yeah. So the applicant will give that evidence to the tribunal. If the fact finder believes the applicant, the fact finder will find that there was no effective service, because although the package was delivered at the address, it was intercepted before it reached the applicant. Someone else picked it and destroyed it. But of course, if the package is delivered and the applicant decides not to open it or not to pick it, then there would be effective service. But whether the package was given to the applicant, ultimately reached the applicant, is, in my respective submission, a question of fact that the fact finder must decide. proceeding on the basis that there is a presumption that it has reached, and the burden of proof being on the applicant. You then have paragraph 30, the example of where some other person deleting the email accidentally or deliberately. An email can also be interfered with by a third party, even where it is password protected. Where, for example, the email is stopped by security and diverted elsewhere. But again, all those are questions of fact for the fact finder. And that, with respect, is entirely correct. It's consistent with the two authorities that I've shown you, consistent with the text of the legislation. Now that appeal failed, and now that judicial review failed for the reasons given at paragraphs 32 onwards. The judge, the fact finder, took the view that the claimant has not rebutted the presumption. Of course, it's a substantive hearing, permission being given, the threshold is different. The judge considered the evidence, looked at the appellant's evidence, and says that the appellant does not even say that the notice has never received his inbox. He uses present tense, that the email was not in or within his inbox. The claimant does not even say that the notice was in deleted items. There is a speculation, this is paragraph 34, what my Lord Justice Peter Jackson was reading from the head note, that an estranged spouse may have deleted the email. That was a pure guess, nothing to substantiate that.
You're also, I suppose, entitled to point to the fact that this was a judicial review.
Full judicial review, yes.
So the permission had been granted.
Of course, absolutely.
On the looking at the earlier part of the report,
Yes.
just before the judgment begins, judicial review permission had been granted by another judge.
Of course.
The grounds of challenge being that the notice had not been effectively served and
course.
that there had been a breach of duty to act.
Absolutely. So this is a substantive hearing. The applicant wasn't able to discharge the burden. He failed.
But they had permission.
Of course. And this is all that I'm seeking from this court, an opportunity to persuade the fact finder that the notice has not been received by the applicant. The fact finder may accept the appellant's account, may reject the appellant account. That is different. But there hasn't been a fact finding hearing. And the threshold for grant of permission, in my respect, submission is comfortably met in this case. There ought to be a fact-finding hearing as it was in that case.
But if there was to be a fact-finding hearing about this, it would be likely to be of advantage to the fact-finding judge to sort out any issue that may exist between you and the Secretary of State about the correctness of paragraphs 28 to 30 of this High Court decision.
Yes.
You invite us to uphold it, to approve it.
Of course, yes. Given that, of course, this court is hearing an argument from both sides on this. Yes, I invite you. Yes, to approve these paragraphs. It's just that with respect, no, the reason why I'm making this submission is because my learned friend invites you to disapprove them. I don't have a problem if the court decides to say nothing about this and leaves it to the upper tribunal to sort it out at the substantive hearing. But it's my learned friend who says, well, disapprove these paragraphs, and I say, well, approve them, and you have to then decide this, whether to approve or disapprove them.
Okay, where do we go next?
So this is these are my submissions on law, and unless there are any questions, I'll now address you on the facts.
Well, there's the guidance, isn't there? But I assume you're going to say, on the delivery receipt point, that too is not conclusive evidence.
it may be a material factor for the fact finder, but it doesn't knock out or doesn't change your analysis.
That is right, but I do also say that the guidance is of no relevance, in my respective submission, to the task of the judicial fact finder. The guidance is for the Secretary of State's caseworkers, for the judge at the Upper Tribunal. It's not, that isn't a sort of statutory guidance, it's an internal document that the Secretary of State has published. Malone Trent is not going to suggest that guidance can assist in ascertaining the meaning of the primary legislation or secondary legislation, or assist the judicial fact finder.
Guidance featured prominently in your original ground.
Yes. Yes, that of course I take no credit for drafting those grounds, but I don't see this case as a case about guidance. This is really about facts, whether this applicant is entitled to a hearing where he gives evidence and.
So you say the fact that there's an internal published policy document.
Yes.
It says that you must ask for a delivery receipt. And there's no evidence in this case that that guidance was followed. May be relevant to deciding the probabilities of the case on fact finding, but it doesn't give rise to any freestanding point of law.
Of course, yes, it does, my lord. Of course, one of the grounds that an applicant is entitled to pursue is that there is a public law error on part of the Secretary of State. The policy wasn't followed. But as I see this case and these sort of cases, the applicant has a sort of superior remedy in the form of a fact-finding hearing. So instead of arguing that the Secretary of State made some public law error, a better argument for the applicant, as I see it, would be to say that, well, these are the facts. The tribunal is the primary decision maker. You, judge, decide whether there is or there isn't effective service. But Malord is absolutely right that it is open to an applicant to say that there is a public law error.
Advancing it, so that's.
But the delivery receipt would be relevant or could be relevant evidence for the fact finder.
Yes, absolutely.
Because it would demonstrate.
Yes, absolutely.
That it had arrived in the inbox.
Absolutely. So I made a submission earlier that in some cases, rebutting presumption would be easier, in some cases would be difficult. If there is no delivery receipt, it can be said, and again, a submission that if there is a remittal that the appellant may make at the Upper Tribunal is that if there is no receipt, then it's easier for him to rebut the presumption. If there is receipt of delivery, then it becomes exceptionally difficult for an applicant to rebut that presumption. But there's no delivery receipt in this case. The guidance, my lord, given that, my lord, you have raised the point. You don't have the guidance, but of course it's
referred to in.
Yes, in the guidance. So the fact finder will take into account the facts, here, evidence, look at all the circumstances, and will then make a finding of fact. So in that sense, the judicial fact finder is in a sort of better position, but surely not bound by the guidance. So if for example, there is no delivery receipt, the judicial fact finder can still find that, well, the presumption has not been rebutted. I don't believe the applicant.
But you say a public law error would only help you to a certain degree, whereas a positive fact find within judicial review would lead to success.
But precisely, yeah.
So that's why you're not interested in pursuing that particular point before us.
Yeah, because I mean, of course, if I lose on facts, then the court isn't going to grant permission on the basis of an arguable public law error, because Malone Trent would then argue that, well, it's highly likely that the outcome would not be substantially different, because on the facts, the case cannot possibly succeed. If I'm right on facts, then I don't need a public law error. So you don't have therefore a pure public law point before you. So facts, Lords, as you know, it's uncontroversial that the applicant had leave to remain until 18th of August 2023. The Secretary of State makes a decision cancelling the leave on 23rd of March 2023. you have that decision in the core bundle at page 95. So the letter you'll see says that leave is cancelled so that it expires on 22nd of May 2023, 60 days. This is the so-called 60-day letter.
Served by email.
Yes. So the 60-day letter, this has the origins in common law jurisprudence of this court. Years ago, this court essentially held that where the Secretary of State seeks to cancel a person's leave to remain, then the Secretary of State, in a case of this sort, should give the person 60 days to sort out their affairs, to find another sponsor, to find another employer, or to leave the country. The reason being that if you become an overstayer, then you are exposed to what is called hostile environment. If you then leave the country and make an application from abroad, that application will be refused on the basis that you have previously overstayed. There is a mandatory ban. If you make an in-country application, that application will be refused on the basis that you are an overstayer. The grounds are mandatory. And therefore, the Secretary of State has developed a practice in accordance with the policy not to cancel someone's leave with immediate effect, but to give them 60 days. So that really is the purpose, to give 60 days to the applicant to sort out their affairs. The applicant's evidence about this is at paragraph, is in his first witness statement, page 114 of this bundle. Now, this is not a mere letter or a submission. This is a formal document, a statement that has meaning and consequences. What the applicant explains in that witness statement is that he did not receive the 60-day letter. Paragraphs 5. He went to a solicitor and asked the solicitor to contact the Home Office for an update. The solicitor then wrote to the Home Office saying that, well, where is the 60-day letter? Paragraph 6, on 27th of June 2023, the solicitor receives a response saying that a notice was emailed. The solicitor then sends pre-action letters, asks for copies of that notice, and the copies are ultimately given on 20th of July. So this is the background, and he says, I'm an overstayer. He then says at paragraph 7 that I have not received any notice or email regarding the curtailment of my leave. I want to confirm that I have never received the respondent's decision. I have no reason to deceive or provide false information to the court. Surely that is plausible. I mean, why would he want to become an overstayer? And again, points for the fact finder, but that's his evidence.
Could we look at, just following through the sequence of events, at page 128, there is a letter of the 24th of June.
Yes.
Is that the first correspondence in the entire sequence of events
Yes.
that began with the cancellation letter of the 23rd of March?
Yes.
So there is no document between the 23rd of March and the 24th of June.
Yes.
And could you just that this is a claim against the fact that a curtailment notice had not been issued.
Yes.
So the public law complaint is that I have parted company with my university and I need a curtailment notice before I can get another university to take me on.
Yes. Yes, or find a job, because when someone is granted leave, that leave is linked to a particular sponsor. So when the applicant had original leave, it's not an option for him to go to an employer and say that, well, I'll go to another university and say that, well, give me admission. The university say, well, you can't because the terms of your leave do not allow you to study elsewhere.
So when considering this letter, which is what, on your case, evoked the response saying, we've served you with a curtailment notice in March, the situation would either be as stated, namely that I've never received a curtailment notice, or if the client is here engaged in a
Lying, yes.
in a complicated and educated defence of his position for having received and ignored the curtailment notice that was sent.
Yes, no, the submission that I is on my list of submissions to make is that there are only two scenarios. The first is that the applicant did not receive this. The second is that he's lying. He is seeking to deceive the court by making a false statement. But the submission is that someone needs to, in my submission, Milan and friend would need to look at the appellant and in his eyes and say that, no, Mr. Dhandapan, you are lying. You are dishonest. This statement isn't true. You did receive this, and you're not being honest. And then it would be for the fact finder to decide whether to believe Mr. Dhandapan or to reject his evidence. So this is his first witness statement. May I just show you his second witness statement, again, inviting you to look at it on a DBNA assay basis, because and you then, after the benefit of patience from both sides, you decide whether you want to.
Well, the first one, page 114, 1st of September.
Yes.
And that was before the Upper Tribunal judge, when he considered the application on the papers.
Yes.
Show us the April 2024 second statement and tell us what it says that
Yes.
it expands on the
Yes.
first statement, but what does it tell us that?
That is not in the first statement. Yes. So it's page 11 of the supplementary bundle. And of course, there is now sort of greater detail, and paragraph 13. So what he has done now is that he has said, well, this is my email address, and I'm now adducing screenshots of my inbox, and I don't know what else I can do. And now the screenshots are inbox, spam folder, and deleted items, and the email isn't there. So the scenario is that either he's a disingenuous, dishonest person who has deleted the email from his inbox and then went to the deleted items folder and double deleted the email and is on a mission to lie and deceive the court. Black and white. Or the other scenario is that what he says is true.
I'm not understanding at the moment the document that was handed in today, which was, I think, meant to be on the back of this statement.
Yes.
Is that right?
Yes.
Only because the inbox appears to cover the period July, August 2022. We've only got one page. Why is that relevant? To anything? we would be looking, wouldn't we, at the inbox for March 2023.
Yes. 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 So I completely take the point. I'm not sure if there is something that is missing again, but I'm happy for you to put that to one side. The submission that I'm entitled to make is that, at least I think I'm entitled to make, is that the applicant's evidence was that he did not receive the email.
Yeah.
It is
That's all in the state, that's all in your.
That's what his statement says. Within the statement, he refers to this. I mean, if this is the entirety of the evidence from the applicant, then the point that my Lord Justice Peter Jackson has entirely properly made will be a point for Miller and Friend to make in cross-examination that, well,
All it seems to show, the later statement, is that he said before the impugned decision was taken that he hadn't received it. And he still says that he hasn't received it. It doesn't seem to add anything at all.
so there's just one further point, which is that this is paragraph 14, he asked another person to look at his inbox, his sponsor.
How can we receive this? I mean, all of this, he was perfectly capable of telling this to when applying for judicial review.
Yeah. So
It's quite unfair to the tribunal for us to be.
So as I've made it absolutely.
My part, this doesn't take your case very much
Yeah,
further,
so I-
even at its highest.
Absolutely. So as I said at the outset, I entirely accept that this evidence is not relevant to the question of whether the Upper Tribunal erred on a point of law.
Good.
If the Upper Tribunal erred,
And we're usually quite happy to look at party and party correspondence, and I found the 24th of June letter from your solicitors interesting, because that's what actually starts the correspondence chain.
yes,
And they are so on the hypothesis that that your client had received the email, somehow deleted it and double deleted it, so on, then his next move must be to tell his solicitors to
yes.
write a letter making no reference to this and saying we're waiting to hear from you.
Yes, so if he's on a mission to mislead, then this is what he would have done. But then a fair point to make on his behalf, not the point that I necessarily make before you, but the point for the fact finder is that, well, why would this person, a law-abiding citizen, he explains in his evidence great lengths to which he has gone to ensure that he does not breach the law, he does not become an overstayer. If he had received the 60-day letter, why, again, a question for the fact finder, why he would not make an application to extend leave? Why he wouldn't do something? I mean, what's the point of him in saying, in doing what he's doing? I mean, what is it that he wants to achieve by sort of cheating the Home Office and the courts? Lord, just to address the point that my Lord Justice Peter Jackson was making, I accept that this evidence is not relevant to the question of whether the judge erred in a point of law. But if you are persuaded that the judge erred in a point of law, you will then have to decide whether on the material that is before you, there is a case that is fit to go for a fact-finding hearing. I'm not inviting you to make any findings of fact, but showing you this evidence to demonstrate that this isn't a hopeless case. This is a case that is capable of belief. One judge in the tribunal can accept the
Well,
balance.
that's why I understand that, but that's why I was querying the fact that you've gone to the unusual lengths of providing a screenshot of an inbox, but not the part of the inbox that one would want to be looking at. And so I'm just wondering whether we've been given the wrong papers, or whether the wrong papers were attached to the back of the statement. Anyhow, there it is.
You'd hear from a learned friend. I mean, if he makes a submission that the claim on facts is hopeless and there is no possibility that a judge would find in the applicant's favor. I'll make submissions on that, but I doubt he would.
And the same, and the sponsor's statement, which is the second statement you sought to put in, the same applies, doesn't it?
Yes.
But that fit, and that would be pertinent to the judge, the fact finder.
So,
Because it would fit into the case being presented in the letter on the 24th of
yes.
June.
So before the fact finder, if the case goes to a fact finder, the appellant will give evidence, the sponsor will give evidence that this person came to me for a job, we discussed this.
It's a tier 2 sponsor scheme, not a study sponsor scheme, isn't it?
This is, because things change and yes, and within the evidence, there is reference to the changes in the rules.
Biggs may say that that's a material distinction between what was said in the 24th of June letter.
Fair enough, but the question for my lord is whether that is the point to make before the fact finder, or whether the point is a knockout blow. Does that mean that my case on the facts is hopeless, or Mr. Biggs needs to put that point to the witness, to the appellant when he's giving evidence that there is a potential inconsistency in what was happening in 2023 and 2024. What's your answer? He'll give an answer, and the fact finder will then decide what to do. The final document, again, not relevant to demonstrate that there is an error of law, are the Home Office records. They're heavily redacted, not sure why. Page 31 of the bundle.
31.
Yeah, page 31 onwards, yeah.
21.
31 of the supplementary bundle.
Yeah.
You'll see that the records say that that there is no primary email address on the record. There is an email address which you'll see that you'll then see whether that email is the primary address. No contactable, no verified, no. Again, these are the points for the fact finder. And then a heavily redacted document, and no suggestion that there was a delivery receipt. See page 36. Now I'm sure there is some reason for the redactions, but the point is that there's no delivery receipt. Again, a point for the fact finder. So this is the evidence and the documents. If I may then take you to the Upper Tribunal's decision. That decision is at page 51. May I respectfully invite my lords?
Sorry. What is 49?
49 is the first decision that was taken by the tribunal on paper. There was then an oral renewal, and the decision that was taken following the oral renewal, which is the subject of this appeal, is at 51.
Right.
While we're looking at 59, paragraph 2 of the reasons.
Yes.
And then we're back to delivery. So do you accept the paragraph 2 accurately records the guidance?
But of course, I cannot. I'm not sure. With
Usually
respect.
that's not a relevant question, don't you?
No, but I'm saying that the respondent's guidance permits service by email. I thought
Yes.
that was going into it. The respondent's guidance actually mandates that there should be a delivery receipt request. But I don't want to waste time on this, but you must ask for a delivery receipt when you're sending out these documents.
Yes, so there is no delivery receipt here, but I'm not inviting the court to grant me permission on that point, because there is.
I was really just wondering whether you accepted that the judge's summary of the evidence was accurate or not. I don't want to deal with it.
Yeah, I do not accept, my lord, that is an accurate summary of the guidance, but not this.
It's taken up in the next decision, which you're just about to take us to.
So page 51. So may I just respectfully invite you to skip paragraphs 2 and 3 just for the time being. I'll address you on those paragraphs shortly. They're about the delay. So it's really paragraph 4 that is relevant at page 52. The judge says that here there is nothing beyond mere assertion that the applicant did not receive the decision. First point that I make is that, well, that with respect isn't correct. This isn't a case about mere assertion. There is a witness statement accompanied by a statement of truth. And of course, that witness statement contains an assertion. And of course, it will contain an assertion in every single case, because this is a case about facts. Second, I say with respect that the judge has not applied the test. The test is whether what is said in the statement is capable of belief. The judge must take the facts as their highest. The judge hasn't said that the factual point that is made is hopeless. It cannot possibly succeed at a full hearing. And that, in my respective submission, is an error of law. And the third point is that I invite you respectfully to see how the judge has phrased the last sentence. There is nothing beyond a mere assertion that he did not receive the decision, which is inadequate. Well, that isn't the test. I mean, this isn't a question for at permission stage whether evidence is adequate or whether it is inadequate. It's ultimately for the ultimate fact finder. So in my respective submission, the judge therefore erred in finding that this case wasn't arguable. It is arguable, and the judge should have granted permission. Just moving on then to the final point about the delay.
Am I oversimplifying? It seems to me you either succeed on both or you fail on both.
Yes.
I can't.
Yes.
If you had rebutted the presumption that the document was served,
Yes.
then that explains the delay.
Yes.
If you hadn't rebutted the presumption, then you lose anyway, and the delay doesn't matter.
Yes.
And Mr. Biggs can tell me in due course whether that's wrong, but it surely stands or falls with the main point.
Absolutely. But the judge, with respect to paragraph 3, thought that wasn't the case, and that was wrong. So paragraph 3, the judge says that assume that the applicant received the decision on 20th of July 2023. So this is the first time the applicant receives the decision the solicitor sent. The judge says that the claim is still out of time. But that surely cannot be right.
If time starts on the 20th of July,
Of course, yes.
your point is it didn't expire before the 3rd of September.
Yes.
4th September.
Absolutely, yeah. So the judge says, well, there is no extension of time application, but one was not needed because.
Isn't he saying that isn't she, sorry, I beg your pardon, she's saying that that's because the date runs for decision not receipt. So that gets us into these issues about what's a decision.
Yes, I mean, yes, so I'm not sure if my learned friend will submit that if the Secretary of State makes an internal decision and keeps that decision on the file, the time to bring judicial review starts running from that date. the time to bring judicial review claim starts running when the decision is made by the decision maker, and the decision is made when it reaches the applicant. Amadi and Mahmood says that you exercise the power to grant leave by giving the notice in writing to the person.
Before that, it goes back to Lord Steyn in whichever case it was.
Yes, but that is, yes, but the position now, of course, is the law is set out in Amadi and Mahmood. When the Secretary of State drafts the decision is legally irrelevant. What is relevant is when the notice is given. I'm sure that plainly is the correct analysis. The Secretary of State, and that is the reason I'm saying that Malad and Friend will not, I hope, invites you to grant permission on the grounds of delay, is that the Secretary of State did not suggest in the summary grounds of defense that, well, the Upper Tribunal should refuse permission on grounds of delay. If the applicant is right that the decision reached him on 20th of July, as a matter of law, the decision is made on that date, and therefore no extension of time is needed. But if I'm wrong about that, then the claim is out of time. So Lord is absolutely right that both questions are linked. If Lords are with me on the substantive point, Lords will allow the appeal, grant permission, and remit the appeal, remit the claim to the Upper Tribunal. If I'm wrong in that, my Lords will dismiss the appeal. Very grateful for your patience. So unless I can assist you any further, these are my submissions.
Thank you very much, Mr. Malik. Mr. Biggs.
Thank you very much, my Lords. In the light of the observations from the bench, what I propose to do is to jump straight into the central issue.
Yes.
Which is in respect of ground 2, and I will then deal with ground 1, but in the light of the observations that I just heard, I'll be as brief as I can about that. We do say that there is a point of principle that this court should be alive to, but I don't want to take too much time on it. As I think the structure of my skeleton argument suggests, the way I've seen this case is that the central issue is in respect of ground 2. If the Secretary of State loses on ground 2, it may be that resolves the appeal. So ground 2 and the effect of Articles 8ZA and 8ZB. The first point I want to make is to extract from Alam and Rana 4 propositions as to the correct approach in respect of Article 8ZA and 8ZB. And having done that, I will then go to deal with the Escobar case and explain why we say Escobar is wrongly decided on this question of whether you can rebut the presumption notice that arises where an email is received into an email inbox. So, the 4 propositions. Can I ask my Lords to turn to Alan and Rana? It's behind tab 7, beginning at page 182 and following. The first proposition concerns paragraph 19, which is on page 188. And the proposition is that the combined effect of Article 8ZA and 8ZB of the 2000 order as amended is that there is a rebuttable presumption that
Would
notice...
you mind if we just read the whole of that paragraph, because the first sentence answers something that was certainly going through my mind, which is what unless the contrary is proved means, the contrary of what?
Indeed.
And the answer is given in that
Great.
sentence.
Of course, I will wait until you read that. So there's a presumption that notice is given where the notice is sent using the relevant method of giving notice authorised by Article 8ZA to little b to f, because as my learned friend correctly pointed out, little a concerns giving of notice by hand, if you like, and that doesn't use the word send, and so that takes you out of Article 8ZB. The background to paragraph 19 is the discussion that immediately precedes it, and it might be worth just looking at paragraphs 12 to 13 for the context here on page 187. I'll just make the point, and then, my lords, you can look at that passage. What Lord Justice Floyd explains at paragraph 12 to 13 is that Article 8ZA itself does not constitute a deeming provision. You can see that at paragraph 13 in particular. So the second proposition, my lords, is that under this scheme, notice is given in accordance with Articles 8ZA and 8ZB. Notice is given when it is received. That is explained at paragraphs 28 to 30. On page 191, going over these. So, paragraph 28, this court identified the dictum of Lord Salmon in Sun Alliance, which we have if you want to look at it, behind tab 15 of the authorities, as explaining what giving notice normally means. It normally means receipt. And at paragraph 29, this court held that that approach applies to the scheme set up by Article 8ZA and 8ZB. So a notice is given when it is received.
Just a moment.
Then begs the question is how received?
Indeed, which I'm going to come to. That's my third proposition. But I would respectfully suggest that it's important to keep separate the concept of giving and receiving, because receipt is how one gives the notice. And so this court, I would respectfully suggest, is looking for whether, on the facts of this case, there was evidence capable of rebutting the presumption of receipt. And in terms of the Escobar issue, I can put it like that, the question is a notice sent by email received, and so is deemed to have been given, once it enters the email inbox of the relevant email address, or is it not received at that point? Is there some scope for rebutting the presumption of receipt, even though it has been received in the email inbox? And just to trail the point, we say, when you break down the issue that way and look at the ordinary meaning of the word receipt, bearing in mind how email works, it becomes clear that you can't rebut receipt at that stage because the thing has been received.
Does that mean that you can, if you establish that an email was sent from your outbox,
Yes.
that somebody can never rebut the presumption that it was received in their inbox?
No, because there is at least some logical possibility of something stopping the email reaching the email inbox. There could be a technical reason for that, a long way beyond my expertise, but one can imagine a case in turning on expert IT evidence about something going wrong in an email server or whatever, so that the email is validly sent, so as to trigger the so for the purposes of
you raise the spectre that in order to rebut, you would need to have expert evidence.
Well, that's one obvious possibility that arises. I mean, there may be a factual dispute. It's perhaps beyond my imagination to give you an example off the top on my feet, so to speak. But the point, my lord, is that there is logical space for rebutting the presumption of an email being received under this scheme.
So what?
But only before it lands in the inbox. Is that what you're going to say?
Yes, because on the ordinary use of the word receipt, and in the light of a common sense experience in respect of emails, when an email enters the email inbox, it has been received.
Well, you'll have to go through that again, so far as I'm concerned, Mr. Biggs, because
Right.
that doesn't seem to me what the scheme of 8ZA and 8ZB is that if a notice is sent in accordance with 8ZA, which includes sent electronically to an email address provided by the applicant, it shall be deemed to have been given unless the contrary is proved.
Yes, of course, and the point I'm dealing with now is that given equals receipt. And so what you can do under this scheme is try to rebut the presumption of receipt. An obvious case where that might be possible is if you had expert IT evidence to say, that, for example, there was a problem with the server. So on the sender's end, everything worked fine, but on the receiver's end, something blocked the actual receipt of the
So
email.
I mean, many people on their emails have a little audible ping when an email comes in. That to put it,
Notification is the word, my lord.
but I mean, your submission to us is that the ping, if that happened to be set, or the arrival, if it happened to be silent, is receipt, and that's the giving of notice. And that the fact that you weren't looking at your email address, or you didn't hear the ping because you were in another room and you didn't look at it, is neither here nor there. After that, your submission is going to be if people then plunder your inbox, that's your problem.
Yes. If you're unlucky enough that your email gets hacked, for example.
Right, don't give the Home Office an address that other people have access to.
Exactly. And of course, we say that's entirely consistent with the purpose of this regime, which is to provide a substantial degree of certainty and predictability for the Secretary of State, but also for applicants too, so that they're conscious of the need to provide.
If you're worried about that, you're going to at some stage come to the delivery receipt issue.
I will come to that in due course. So can I? So I just wanted to be clear that there is some logical scope for saying that an email has not been received, even if receipt means entry into the email inbox for the reasons I've given.
Sorry, it is still open to someone to say they haven't received it, even if it's in their inbox.
Yes, not if it's in the inbox, then it's been received. But it is open to a person to say it never reached my inbox.
Yes, sorry.
That's the point.
I misheard what you.
No,
that's
I'm sure
that
I
was your
misheard.
original position. I misheard your
Right.
restating.
Sorry, the order doesn't use the word receipt, does it?
As the order was interpreted by this court in Allen and Rana, a notice is given where it is received, and that's the proposition I'm on. So if we go back to paragraph.
On this interpretation, on this submission, paragraph 30 is pretty important.
Indeed, and I'm dealing separately with the concept of receipt under this scheme, which is my third proposition, which I'll get to, I promise, right away. But just to close off at this point, which is that receipt equals notice being given under this scheme, I've referred you to paragraphs 28 to 30, but it's in particular paragraph 28 and 29. And you can see the court's reasoning. What the court did was to look at how the courts have interpreted the concept of giving notice in earlier decisions, in particular in the Sun Alliance case.
Yes.
And adopted the same approach under this scheme. So Sun Alliance recognised that you give notice notice is given, when the notice is received, And what the court was trying to explain here, this is the second point I just want to make on this topic before I move on to what receipt means. What the court was making clear at paragraph 29 in particular is that it's not necessary for the recipient of the notice to be aware of the contents of the notice for there to be valid receipt, for there to be
Well, of course,
valid notice.
but I mean, 28 Lord Salmon and Son Alliance
Yes.
That's well established. The requirement for the giving of the notice can be complied only by causing the notice to be actually received. Next question is, what does actually received mean? 29, now, the 20th century concept of something being sent through the post. It's no good if failure to open the envelope doesn't mean the notice hasn't been received, otherwise nobody could ever serve notice of anything. Fine, but then 30 is obiter because the ALAM is about recorded delivery email. So the question is, what is meant by receipt of an email will be effected by the arrival of the email in the inbox of the person affected?
Yes. So paragraph 29 makes the important point that you can receive the notice for the purposes of this scheme, and therefore the notice is given for the purposes of this scheme, whether or not you bother to read the notice or pay any attention to it. Paragraph 30 explains what receipt means. This is my third proposition. And the submission is that receipt does not have a narrow meaning. And we'll have to spend a bit of time on paragraph 30. But doing the best I can with paragraph 30, what the court was saying is that there is receipt where the method of giving notice used under Article 8Z A concludes.
Yes, Lord Justice Floyd allows for the possibility of interception after it arrives after a letter arrives at the address.
Yes, and
The
I'll
Lord's example of it being swept up and put in the recycling off the hall table.
well, that's perhaps a borderline case, because if we look at paragraph 30, and in particular the passage beginning, "In my judgment, however, receipt in the case of an individual is not so limited," where we then see the example of receipt by email, which was not followed in Escobar. We say Escobar was wrong not to follow this. But you then see a passage that has to be, on any view, part of the ratio decidendi of this decision, because Alam Arana concerned notice by registered mail. And Lord Justice Floyd says this: likewise, documents arriving by post, this is at the top of page 192 next to A, likewise, document arriving by post will normally be received, if they arrive, addressed to the person affected at the dwelling where he or she is living, at least in the absence of positive evidence that mail which so arrives is intercepted. A document received at an address provided to the Secretary of State for correspondence is received by the applicant, even if he does not bother to take steps to collect it. So the point there is that if, and I think Lord Justice Floyd gives this example elsewhere in the judgment, if someone is unconcerned about their mail, so they allow the mail to accrete in a neglected part of the hallway, and then they throw everything into the bin without looking at it, that still constitutes receipt.
Yes.
And so because of that, it may be that the example that was put to my learned friend about mail going onto a communal table and then someone picking it up is a borderline case, because you could argue there that the person to whom the mail was addressed had demonstrated disinterest in respect to the mail, and so it was validly received. But of course, we're not dealing with this that situation in this case. What's perhaps most important about this passage, about paragraph 30, is the concept of interception, as being an example of where you can rebut the presumption of receipt.
It's not the only one. I mean, I'm sure I've sat on many cases about documents sent by mail, but actually delivered by the postman to the wrong address in the road. Now,
Then on any view there would be no receipt because
Yeah.
something has gone wrong with the delivery process. So on my attempt to sort of summarise what's being said at paragraph 30 in Alum and Rana, the method for giving notice that has not concluded because something's gone awry should have resulted in the mail going through the letterbox and then finding its way to the person in property A. It's actually found its way to property B. And in that situation, there wouldn't be valid receipt. Now, in terms of interception, in the context of physical mail, which is the only context in which interception is mentioned at paragraph 30, in my submission, there is logical space for the concept of interception to work in respect of physical mail, because a letter addressed to a person is a means by which that letter is provided to the person. And this is an example given in Escobar by Counsel for the Secretary of State in Escobar, and indeed it's an example that resonates with the facts of Alum and Rana, in particular the Alum case. If you have a property that is in multiple occupation, or perhaps a block of flats, the notice can be received at the address in the broad sense of the address, but it doesn't actually get to its final destination, so that the method for effecting the notice hasn't concluded because it's intercepted at that last stage. It goes through the letterbox, but it doesn't find its way onto the mat in front of the door of the flat, or it's intercepted by someone who is occupying the shared space. In that situation, it might be coherent to say that the notice has not been received because it's been intercepted. And in my submission, that is what Lord Justice Floyd had in mind. But that is a very long way away from the situation considered in Escobar, because in respect of emails, the method for giving notice authorised by Article 8ZA has completed by the point the email is received into the email inbox. There's nothing at that stage left to rebut. The receipt has happened, and at that stage, all you can really argue about is whether you had knowledge of the contents of the email.
Does Article 8ZA mention inboxes?
I don't believe so, my lord. No, No, Article 8ZA simply says, as far as is relevant here, so this is on page 28 in all of the authorities. The notice may be sent electronically to an email address provided for correspondence by the person or the person's representative.
So on what basis do you seek to narrow the scope to rebut the presumption by introducing this concept of arrival in the inbox is conclusive?
Because it goes back to what giving notice means under the scheme, which is the second of my 4 propositions. Giving notice means receipt, and once the email has been received in the email inbox, it has been received for the purposes of this scheme. So there's nothing at that stage left to rebut. All you can rebut at that stage is...
Sorry to interrupt, but how do we know it was received in the inbox?
Well, that's the question. Well, I'll come on to the evidence in this case, and I'll explain why the evidence overwhelmingly shows that it would have been. And of course, there's a presumption that it would have been, so the burden is on the person saying it wasn't received. That's one of the ways that this scheme operates in a way that's practical and affords some benefit to the Secretary of State in respect to decision-making following the Said decision of my learned friend.
Why not use the delivery receipt system?
Well, that may well be why the policy is framed in the way that my Lord Justice Jackson has pointed out. And I'll come on to the evidence in this case in a moment. But what this
inboxes are concerned, 8ZA2D says sent electronically to an email address. Well, that's where an email address is It's another way of, if you send it to an email address, it goes into an inbox. That's
Should
if,
do.
It
yes.
might go into a junk box, it might go,
Well, that would probably be sufficient. I mean, because that's an internal process. It's still been received at that stage, and the burden at that point would be on the migrant to, as the burden is on all of us these days dealing with emails, to make sure that one manages one's email system so that you receive important notices or that you're aware of them. But I mean, one possibility, my lord, could be that the email address is no longer in use, for example, and at that stage you get a bounce back. Or there might be some technical problem with the email address or its ability to receive emails, and then you might get a bounce back receipt. I mean, I don't think it's giving evidence to suggest that we've all had experience of emails not sending properly, and eventually you get a notification that it didn't work, or you can certainly get that. In that situation, it would be open to the applicant, to a migrant, to say, well, you use the method of service for the purposes of Article 8ZA, but I didn't receive anything. And the evidence for that should be that I don't have this email. This email is no longer being used, and you should have got a sort of bounce back confirming that the email wasn't received. And in that situation, there shouldn't be any problem. There would have been no receipt, and so there would not have been any notice.
We've been asking a lot of questions. You said you had 4 propositions.
Yes.
Why don't you say without argument what the 4 propositions are, and then so we can see what's
ready.
coming.
finish the third one.
Yeah.
Let me just finish. Just to be clear, I don't want to miss anything. So the third one is receipt does not have a narrow meaning. It encapsulates essentially the completion of the method of giving notice authorised by Article 8ZA. And perhaps just before I move on to my 4th proposition, I should just deal with the case of giving notice by hand. And we'll come back to this. I'll come back to this by reference to the Escobar judgment. This analysis is consistent with the way Article 8ZA operates in respect of notice given by hand, because if you are handed the notice, there is no logical space between the giving of notice by hand, the handing of the notice, and receipt. And so there's no need at that point for any presumption that notice has been received, because the act of giving the notice itself is equivalent to receipt. There's no logical space there. So in my submission, this broad approach to receipt that I sought to outline and is set out by Lord Justice Floyd for the court at paragraph 30 of Allen and Rana is entirely consistent with the scheme and makes the best sense of it. The 4th point is, or proposition, is that there is a weighty burden on a person who seeks to rebut the presumption of receipt under this scheme. That is made clear at paragraphs 31 to 33 of Allen and Rana on page 192. It's 31 all the way to 33.
Yeah.
33 makes the point explicitly. Follows that the burden of proving a negative non-receipt in the face of convincing evidence leading to an expectation of receipt, and just to flag the point, we say that this case is very much in that category, will not be lightly discharged. In particular, not discharged by evidence, far less mere assertion that the notice did not come to the attention of the person affected. And then at paragraph 32 to 33, Lord Justice Floyd recognises the sort of practicalities of this approach, and he draws together the correct approach to take at the permission stage at paragraph 33. And on a close reading of those 4 points in the subparagraphs between E and G at paragraph 33, you can see, my lords, that there is still a high burden, or a heavy burden, I should say, for an applicant for judicial review to satisfy, even at the permission stage, by way of their evidence seeking to demonstrate a realistic case that they can rebut the presumption of receipt. You can see that in point B. Litigant will need to do more than show that the notice had not come to his attention, but establish how he proposes to show that it was never actually received in the sense which I've explained, which I've also tried to explain. And then C, question will be whether the material before the court raises a factual case which could, taken at its highest, could properly succeed in a contested factual hearing, but bearing in mind that relatively high threshold that's set out at B, and is mentioned at 31. So those are the four propositions of law in respect of Allen and Rana.
Can you just repeat 1 and 2?
Yes. So
Yeah.
1 is that Articles 8ZA and 8ZB taken together provide for a rebuttable presumption that notice has been given.
Yes.
Where notice is sent using one of the relevant methods of giving notice.
Yes.
The second point is that notice is given for the purposes of that presumption where it is received. And that brings us into what is probably the central issue in this case. What constitutes receipt? And I've tried to explain that by reference to paragraph 30 of Allen and Rana, which was the third of my 4 propositions I spent some time on.
Yes. Thank you.
Can I just ask one point by way of clarification? I don't want to take up too long, but you've emphasised the importance of the arrival in the inbox.
Yes.
And are you saying that that if it is sent to the address, and established that it's been sent to the address, that precludes any possibility of rebutting?
No, because of the points that I tried to make in answer to my Lord Justice Peter Jackson's observations. You could, for example, have a case where the email address is no longer being used, it's defunct, if you like, in which case you would expect to receive a bounce back or something like that. You could have another case where it's a bit more difficult, where expert evidence might, in practical terms, be required to show that there was some technical reason why the email didn't enter the email inbox that the expectation is it would have reached. But
why is the possibility, not Mr. Justice Sheldon's possibility in Escobar, not legitimate? Why is it not legitimate? Why is it not a theoretical way? That's all we have to talk about because of this argument. A theoretical way of rebutting the presumption that although it got to my inbox, I never saw it because it was deleted by my spouse.
The short and I hope pithy point is that, yeah, I'm grateful. The short and I hope pithy point is that that's not conceptually possible because it conflates the knowledge of the contents of the email with the idea of receipt of the email. And under this scheme, as was explained by this court in Allen and Rana, notice is given by receipt, and it doesn't matter whether you become aware of the contents of the notice.
No, but don't you have to know that you have received something? Isn't that the point?
Well,
if my Lord gives me a letter and I don't open it, I don't know what's in it, but I know I've been given the letter.
Well,
if I've got it, sorry.
No, forgive me.
You see the point.
I do, my lord, and I'm sorry, I shouldn't have interrupted you. I was thinking through my response. I think if one goes back to paragraph 20 all the way 20 to 27, I don't intend to look at that right now, but if one looks through paragraph 20 to 27 of Allen and Rana, where this court looked at the suggestion that you need actual communication of the notice and rejected that suggestion, I think you'll get to the answer. The point is that receipt is something different from communication of the contents of the notice, and actually all that's required, and I think this is probably paragraph 26 and 27 on page 191, all that's required is that you have the opportunity of gaining the knowledge of what's in the notice.
Doesn't that involve knowing you've got it? How can you have the opportunity if you don't know you've got it? That's why if my Lord gives me a letter, I know I've got it, even if I don't know what's in it. But
well, if in the ordinary course of events, if one has an email inbox that's functioning in the sense that you receive the email into your inbox, even if it's in a junk folder or whatever, you still have the opportunity, if you act with proper diligence, which the Secretary of State is, in my submission, entitled to expect of a migrant, you have the opportunity then to open the email and consider its contents. In just the same way, my lord, as you have the opportunity in respect of physical mail, if the mail is addressed to your home address or even an address in joint occupation, and it comes through the letterbox, you then have the opportunity to actually take your mail seriously, open the envelope and look at the letter. But if you neglect to do that because you're not interested in your mail, or
You can leave it lying on the mat.
exactly, then that's not going to help you, because you still have the opportunity to go through your mail and look at and open it and consider its contents. There's no conceptual difference, no difference, I would respectfully submit, as a matter of fairness between those two situations.
But we're not fact finders. But at the moment, you seem to be creating an effectively insurmountable hurdle. If the delivery receipt system isn't used, the appellant says in a witness statement, I never received this. And speaking of myself, the fact of the solicitor's letter of the 24th of June is quite strong supporting evidence. But anyway, the Upper Tribunal judge says none of that is even admissible or arguable. In other words, I find you're a stinking liar. On what basis? That it is impossible for something sent to an email address not to be received in the sense you're suggesting?
No, my lord, I try to be clear that it is entirely possible that an email can be sent and yet not received. Technical problems, the email address to which it's sent being defunct, for example.
But it doesn't have to be that. In our ordinary experience, your nearest and dearest or close friends send you regular emails, and then one day, email is diverted to spam. Don't know why. And if it's somebody who doesn't write to you very often, they send you an email, it's diverted to spam, it's deleted after 30 days, you never know you had it.
Well, I think...
How do you prove that?
Well, I think that if I may, there are sort of two responses.
Hmm.
The first is that there's actually a separate issue in this case as to whether the evidence was sufficient to give rise to a realistic prospect of the applicant rebutting the presumption of receipt, even if I'm right about Escobar being wrong on this.
Hmm.
And I think, my lord, that's possibly at least part of the thrust of my lord's question. And I'll come on to that and deal with that separately.
Yes.
At the moment, I'm dealing with a conceptual or legal point as to what constitutes receipt and therefore what you can rebut for the purposes of this scheme. And I would respectfully suggest that even if it results in hard outcomes, this scheme is properly calibrated to provide that receipt takes place when an email enters the relevant email inbox. In just the same way that I think the CPR, the Civil Procedure Rules, work in this regard. I don't think it would be open to a litigant in person or someone acting with representation to say, well, I wasn't validly served with this document by email because it went into my spam folder. So we are dealing here with a regime that inevitably sets up bright line rules, which in some cases might work results that strike the court to some degree as unfair, but that is a permissible regime.
So really you're introducing some sort of duty on a prospective recipient, aren't you? And with the interesting distinction we touched on about post.
Mm.
If a letter is, if you're in a shared occupancy house, letter arrives, put on the hall table, and then swept away by a third party immediately into the recycling, not received. If left on the mat, left there with all the other bills and whatever, not exercising due diligence to open your post, not received. Similarly, if it's gone into spam, you bother to check your spam, or you've not opened your emails, which not all of us open our emails straight away, Mr. Biggs, if I can, full confession. If in those circumstances, tough, received. But if something else has happened, it's gone wrong for some technical reason you can't explain, or whatever, so then there's a distinction. Is that right? There's a, in terms of there's duty to deal with your post and correspondence.
It's not a legal duty. It's a pragmatic one.
Pragmatic duty.
I mean, it's not a duty at all, I would respectfully suggest. I mean, what we're dealing with here are the realities of life. All of us have to take correspondence seriously, unless because there may be consequences to receiving important correspondence that we don't deal with.
Isn't it ultimately a matter to be determined by a fact finder? These issues, rather than have it try to impose a bright line as to when it arises and when it doesn't.
Well, ultimately, of course, what this court has to do is to properly construe this legal scheme and to effectively recognise how it works in practice and then apply it to the facts of this case. My submission is that this legal scheme properly does draw bright line distinctions. There is a helpful analogy between physical mail and email in this context, and I think Lord Justice Floyd was very clear that if you receive physical mail and you neglect to open it and it just piles up in the part of your house which you never go to, for example, then you've still received the notice. You couldn't turn up 6 months later and say, I'm sorry, I didn't bother to look at that. I just don't check that pile. The same logic would apply in respect to the bright line rule that is set up in respect of email. That's my submission. In my submission, when everyone's dealing with a scheme like this, there will be bright lines that might result in hard cases, but Parliament is entitled to set a scheme that operates in that way. And indeed, the benefits of the scheme would be significantly undermined if it didn't operate in that way, because it would effectively mean that it would always be open to an applicant to come to the tribunal or to court and to say, well, I didn't actually get this thing, I'm going to have a trial. And that would largely undermine the value of the scheme in my respect for submission. So can I move on to deal with Escobar specifically, which I think I've largely covered, but I think I do, to be fair to Mr. Justice Sheldon, need to look at his particular reasoning and to make I want to make a few points in respect of the specific reasons he gives.
Yes.
The relevant passages are paragraphs 27 to 31. They begin, paragraph 27 in particular, begins on page 205 of the authorities. For those of you using hard copy, it's tab 8, beginning at 199, but the relevant passages begin on page 205. And I'll just make a few points, if I may, in respect of this reasoning, paragraphs 27 to 31. So looking at paragraph 27 first, and the third sentence beginning the 2000 order deems, with great respect, I don't think much turns on this, but with great respect to Mr. Justice Sheldon, that doesn't seem to be right, because it overlooks the fact that it's Article 8ZB that creates a rebuttable presumption in combination with Article 8ZA. It's not Article 8ZA on its own that triggers a rebuttable presumption. We looked at that earlier by reference to Allen, paragraphs 12 to 13, and paragraph 28 to 29. Paragraph 28, top of page 206.
Where is that error in the judgment? I didn't spot it.
Well, as I say, it may not be particularly significant. Just where it's the third sentence beginning the 2000 order. I'll just read it.
No, I've got it. You mean in 27?
Yeah, 27. Yes.
Sorry, thank you. No, please carry on. 28. You were going to.
So the point I'm just making then, as I said, I don't think it really matters very much, but what Mr. Justice Sheldon seems to be saying there is that Article 8ZA is the provision that triggers a deeming of service or notice. So it said that the notice is given when it's sent by email, but that's not right. Under the scheme, there's a presumption of receipt, and it's the presumption of receipt which is the giving of notice. Paragraph 28, top of 206. This is a point I think that my Lord Justice Bailey put to me. The 2000 order does not state that once an email enters the inbox, it should be treated as given. Well, that's right, but in my submission, that doesn't matter because, as I've tried to explain by reference to Allen and Rana, the key concept under this scheme is receipt. And receipt does arise where the email is received into the email inbox. And the point by reference to given by hand that Mr. Justice Sheldon uses to buttress the first part of paragraph 28, if that makes sense, I've already tried to deal with. That's not a good point because if you give notice by hand, inevitably the person has received the notice because you can't logically separate the giving of notice by hand and the receipt. You hand something to someone, they take it, that's the receipt.
What's wrong? I don't follow. Sorry, Mr. Not too blunt there. I don't quite follow what you say is wrong with 28. Why is it not right that Parliament could have made it equally clear?
Well, this is building up to the conclusion. So I don't.
So we're taking it right up.
Right. I'm saying there's not any rhetorical force in this passage. It's right, of course, that Parliament did not say in terms that once an email enters the applicant's inbox, it should be treated as having been given. But actually, when you read Allen and Rana, the key concept under this scheme is receipt. And as I've tried to explain, an email is received for the purposes of this scheme once it enters the email inbox, as Lord Justice Floyd pointed out in terms, albeit by way of example, of paragraph 30. And there's absolutely nothing wrong with that. That makes perfect sense of the statutory scheme, and that brings me to the second point I've made by reference to paragraph 28, which is that this suggestion that there's something that undermines the suggestion that you receive an email when it enters your email inbox because of the way that notice given by hand is dealt with under the scheme is not a problem. Because when you give notice by hand, you also receive the notice. There's no distinction between giving of notice and receipt in that context. The next point I want to make is in respect to paragraph 29. This is the point about the observations of Lord Justice Floyd at paragraph 30 being obiter. Well, we've respectfully suggested in the written argument that that's perhaps not right, because Lord Justice Floyd was using his understanding of how service or notice by email works to inform his decision in the case at hand, because he had to understand what receipt means, and he explains what he meant by receipt in part by reference to what he understood email receipt would constitute. So it's arguable in my submission that actually what Lord Justice Floyd said at paragraph 30 in respect of email receipt is part of the ratio of the decision. But I don't want, with great respect, to get into a difficult argument about stare decisis. My point is that what Lord Justice Floyd said at paragraph 30 is correct in respect of email receipt.
Well, let's just have a quick. Can we just go back to it?
Paragraph 30.
Yeah, is it quoted? Oh, yes. Is it quoted in this journal? Or is it go back?
We can go back to it. I think it's 191.
Yeah.
So what?
Is it your case that its arrival in the inbox that gives rise to a receipt, or arrival in the account?
Well, I think if the email arrives is received in the email system, so that it's in an inbox or a message box, however you want to describe it, and we're getting into highly technical matters, but that constitutes receipt. I would respectfully suggest that there can't be a difference that matters between, say, an email being received into a junk folder and an inbox, the inbox folder or prioritized folder or whatever.
What was Lord Justice Floyd intending to mean? Did he mean inbox, as he said, or did he mean to the address of the individual email address?
I think what he meant was that the email is received into one of the folders that receives emails.
That's not what he said, though, is it? He said inbox.
He did, but again,
inbox is one of dozens of folders on my account.
I acknowledge that. if I may, I'll put it this way. In my submission, there's no compelling conceptual distinction between inbox or some other box that receives emails. What matters is that the email has been received into an email folder that's used by the relevant software for receiving the email. After all, the way that an email program works is, to a degree, esoteric. It depends on how it's been set up, the particular software that's used, and there are algorithms that often do things that one perhaps finds unexpected. So for the law to function, drawing a fine distinction between a junk folder or an inbox in my submission is unattractive.
Well, it might be said that Lord Justice Floyd was using it more precisely than you're giving him credit for.
Well, perhaps. I mean, well,
Insofar as it is a considered observation by Lord Justice Floyd, which one would expect, frankly. Why shouldn't we assume that he meant, when he said inbox, he meant inbox?
well, I think I've said all I can.
Yes.
Indeed, in
that.
your submissions, you did use inbox.
Yeah.
Yes. I mean, just coming back to Escobar, I mean, the point,
Yes.
even receipt to an inbox wasn't good enough for Mr. Justice Sheldon, with great respect. So Mr. Justice Sheldon in Escobar thought that it was wrong to say that you received this notice, even if it's received into the inbox. And we respectfully submit that that's wrong. And finally, in respect of Escobar, can I ask you, my lords, just to go back to paragraph 30 of Escobar, on page, I think, 206. And this really gets to the nub of it, and I think I made the points already, but if you'll just indulge me. We do say that it's not theoretically possible to intercept an email that has been received into the relevant message box, inbox. I'll just use that concept, because interception by its nature means interfering with the process of delivery. Once, and therefore with the process of receiving something. Once the email has entered the relevant inbox or box, it can't be intercepted using the ordinary English meaning of that word. It's already got there. There's nothing at that stage left to intercept. What you could do is delete the email, which means the information in it couldn't be accessed. But we know that there's a difference between accessing and having knowledge of the information in the notice and receiving the notice.
I think, as I read this judgment, Mr. Justice Sheldon is using interception to mean by a person, as opposed to electronic diversion, which he's not considering.
Yes.
And what you've said about diversion to junk, well, we've got that point.
Right.
Not saying I agree with it, but Mr. Justice Sheldon is talking about some human being
Yes.
interfering.
Yes. And he's doing that by analogy with physical mail, which was, of course,
Yes.
the subject of these observations of Lord Justice Floyd in respect to interception and paragraph 30. And it's also the subject of the Kelsey decision, which I'll deal with very briefly in a moment. So we say that there's just no scope for the concept of interception to apply in respect of emails once the email has been received into the email inbox or whatever the correct box is. You could, without too much straining of language, use the concept of interception if, say, someone blocked the email from getting to the appropriate recipient's email inbox in some fashion, and we wouldn't have issue with that. I've explained or tried to explain that the receipt only takes place once the email enters the email inbox or the appropriate folder within the email software. So there is that possibility of rebutting a presumption of receipt.
Could you deal with this example? Suppose a person who has a mobile phone and that's the only place they have an email account and that's where they operate their account from, and the phone gets stolen or destroyed for some reason. Now, you as the Secretary of State are entitled to send notices to that email account, or the AZB route. How does it work out? It has been received in this phone, which the person has no control of, according to your analysis, because it's arrived, let us suppose, in the account.
Yes.
How does somebody go about rebutting receipt in those circumstances if in fact it has been received?
I think they wouldn't be able to, in just the same way that in respect of physical mail, if you change, let's say you move out of an address, and perhaps even shut up the address, lock it down for whatever reason, and mail is still being received through the letterbox there, you couldn't then complain under this scheme that you.
This is the hard cases situation. Let's suppose one's house is burnt down, and therefore mail cannot be delivered to it. Nevertheless, it has been received.
I would respectfully disagree with that, my lord, because if it's been burnt down, the address no longer exists. I think that would be the point there.
Let me withdraw that one. But staying electronic for the moment, that you would say the person who's lost control of their phone, that is a hard case, and the only remedy for them would have been to contact the Home Office and to replace the account with something different.
Yes, so the expectation would be that a migrant would contact the Home Office once they realise there's a problem and would do that promptly, and I think that's perfectly reasonable for the Secretary of State to expect. And of course, if for some reason that didn't happen, or there's some good reason for that not happening, or that it didn't matter because of just unfortunate timing, the Secretary of State always has a residual discretion to take action in order to deal with the justice of the case. So she could, for example, grant leave to remain as a matter of discretion if that was considered to be appropriate, given the difficulties in a particular case. I think, my lord, that would be the solution in that situation.
Thank you.
Would you just like to say something about the guidance, delivery receipt guidance?
Yes, my lord, I'm conscious of the time. I don't have a huge amount more to say. If you want me to say something about the guidance before lunch, I'm happy to do that.
How long do you think it would take?
I can deal with it very quickly. The relevant guidance is at, I think, page 26 of the supplement. 26 and 27. For the relevant part of the guidance, it begins at page 22.
Does this guidance apply to this case?
It does appear to apply, yes, it does. I think
only asked because the tribunal seemed to think it didn't.
Well, the argument that the judge below was confronted with was that the guidance had not been complied with, and that that constituted a material public law error. And I note that my learned friend disavows any argument about material public law error, which is probably the key point for me to emphasise. The argument before the Upper Tribunal was that part of the guidance that requires recording of a delivery receipt was mandatory and had not been complied with. So that's the part of the guidance that appears at the top of page 27. The last bullet point there. If you receive a delivery receipt. That was the argument that was presented to the Upper Tribunal. And the answer to that argument is that there was no delivery receipt received, and so it was not recorded on the Secretary of State systems. So this is the observation that the Upper Tribunal judge makes in respect of that argument. or explains the observation that Upper Tribunal Judge Leslie Smith made in respect of that argument. She pointed out correctly that this part of the guidance, that the obligation to record the delivery receipt, only applies if you receive a delivery
To
receipt.
send a delivery receipt request.
I
3 bullet points higher up.
My lord, you're quite right about that. That wasn't the basis of the argument below. The argument below was that there was no recording of a receipt of a delivery request.
But it is clear, is it not? In this case, the 23rd of March letter was sent by email, but it was not accompanied by a delivery request receipt.
Receipt request.
Sorry, delivery receipt request.
I've taken instructions on this point because I
Yeah.
appreciate it. It's a concern to the court. Our position is that we're not sure whether it was or was not,
Yeah.
because there's no recording of that request having been made. However, the usual practice is to request a delivery receipt, obviously in accordance with the policy, and we're just in an evidential difficulty because we can't point to anything that shows that that request was made in this case. And it may be that that's because the systems don't automatically record the making of a request; they only record the receipt of the confirmation of delivery once a request has
Isn't
been
it
made,
arguable?
which didn't happen here.
Isn't it at least arguable from the fact that a receipt wasn't recorded, that it was never requested?
Well, that's one possible inference. I certainly accept that.
But if it had been requested and it had been delivered, you would have confirmation.
One would expect that, yes, I accept that. The evidence before the court that I'm aware of doesn't indicate that there was a receipt, a delivery receipt received. So that's the best I can do. I mean, this is not a point that has been run on appeal, so it's not a point that we have spent a huge amount of time.
No, it's not. Mr. Malik is not saying failure to prove that a delivery receipt request was sent means the whole thing is invalid. What the point as I see it is, if you're arguing that any lessening of the extremely strong presumption, say, that email is sent, it's been received, would bring the whole system crashing down. The answer to that is, if the notice is sent by email with a delivery receipt request and delivery receipt is received, then the applicant is going to have a hell of a job persuading anybody that the email was not received into his inbox.
Well, with respect, not if Escobar is correct, because it could always be open. It would always be
No,
open. to
then
the
you can
applicant
argue
to then
interception,
say,
but yes.
or that they inadvertently deleted it, as I'm
Yes.
sure we're all guilty of doing. I mean, that's frankly why we've taken the point in respect of Escobar, because it does make the scheme difficult from a pragmatic point of view.
Yes.
My lord, I'm conscious of the time. I don't know
Right.
how much more assistance I can be
Any
at this
questions
stage.
from
I
Mr.
do have a
Davis?
bit more to say.
Questions from Mr. B?
Don't think it's finished.
Sorry, my lord is saying he's not sure that you've finished, Mr.
I
Biggs.
haven't finished my submissions. I
Oh,
have more
right.
to say. I'm just
Oh, right.
conscious that
All
we're
right.
now 10 minutes into the luncheon break. That's all.
Right, 2:10, Mr. Biggs.
Court rise, please.